I want to ask you about the immunity. I guess that's it. Thoughts?
All right.
The two people are expecting this on Thursday, I guess, but I don't know if you have other.
Well, look, it could be Thursday. It could come Friday. It could come next week. It could come the week after. We expect it before July 1st and I kind of expect it to be a sort of last day of the term sort of thing. Partly
so why do some people think it's Thursday? What they're just hopeless
because
optimists?
It's a decision day.
Yeah.
And so everybody's expecting it every decision day.
Got it.
But I'm thinking if you're Sam Alito and you've dragged this thing out, or if you're Clarence Thomas and you've dragged this thing out, why not drag it out a few more days? Because you can. So that's just my instinct. But at the end of the day, the 2 weeks between now and the end of the term is not going to make much difference. The question is how restrictive or permissive the decision is when it comes out. If it's permissive with respect to the district court, I expect Judge Chutkan will move quickly. She's had a lot of time to get herself ready to move quickly. I also expect, remember that there's two cases that bear on, one is the immunity case. The other is the Fisher case, which has to do with the scope of one of the statutes that's at issue. And I expect the special counsel will do some very quick reading of the decision, deciding, do we need to drop a couple counts to make this move faster? Do we need to narrow the indictment to if they say certain acts are, protected by immunity, you could just drop those acts out of the indictment. So I think what you should expect is you're going to get two decisions, and they're not going to do anything until both of the decisions are out because you don't want to have to react twice. They're going to have, then you're going to see, depending on how those opinions are written, you're going to see the special counsel walk into court and say, we want to proceed, we want to drop count 3 and count 1, and we're going to proceed on 2 and 4, and we're going to drop the following passages from the indictment, and we want a trial date in a week and a half. And the Trump people are going to respond a la the New Yorker cartoon, no, that doesn't work for us. How about never? Does never work for you? And Judge Chutkan is going to try to set a trial date, and we're going to see she's promised him 88 days. We'll see if she decides to stick with that promise or if she moves ahead faster. But I think, people are going to be surprised at how fast this moves once she has a green light, assuming she gets a green light.
Well, the host of the Bulwark Podcast is certainly kind of surprised. I've chalked it by that take. I've chalked this up. 88 days after July is the end of September. She's really going to hold this trial 1 month before the election.
So remember, she can argue legitimately she was prepared to hold it in May. The reason this trial has been delayed is because of the Trump request to have this stayed and appealed. The delay is entirely at Trump's request. So I think she's going to, I have seen no indication from Judge Chutkan that she does not have a fire under her butt about this.
Back to the decision side of things, I'm not asking you to be a predictor of what, I guess, who are the swing votes on this? Roberts and Coney Barrett.
And Coney Barrett.
Yeah. So I guess, why don't you just break that down for us? What is kind of expected on how the court is going to break down on the immunity ruling? So
I think there are, as best as I can tell, 0 votes for the hard version of immunity. Even Justice Alito at the oral argument did not entertain the most extravagant claim of immunity. So assume there are some
that the president can just drone, that Joe Biden can just drone Donald Trump, that Alito's like, no, I draw the line at that.
At droning your political opponents.
Got it.
So I think there will be 9 votes for the idea that there is not absolute immunity for everything. And so there will be, I think, 2 or 3 votes for the idea minimum that there is no immunity for anything. And so then the question is, in this group of that would believe that there is some immunity for official acts, how do they treat the allegations in the indictment with respect to whether they are or are not official acts? Do they say there's absolute immunity for official acts? Do they say there's some qualified immunity for official acts? And how do they define the official acts? Now, Amy Coney Barrett, who's by the way, whose performance at oral argument was terrific. I mean, she was a real grown up and very serious.
At one point, I think Trump thought he was getting Eileen Cannon with Amy Coney Barrett, and
well,
she's not exactly been our progressive listeners' idea of a model justice, probably, but she's not. She was a model justice in this oral argument. It was a very serious performance, and she actually walked counsel for Trump through a series of allegations in the indictment and said, is this official or non-official? And he conceded that a lot of it were non-official. And so I think you could imagine 5 or 6 votes for saying, there's some form of immunity for official acts. We remand it to the district court to decide which are the official acts in here. And some group of them saying, but clearly a lot of this is not. And then Jack Smith would have to decide, do you just purge the indictment, file a superseding indictment that's purged of a lot of the stuff that's plausibly official? There's not that much in there that's plausibly official. Maybe the stuff about firing the attorney general, replacing him with Jeff Clark, those are official acts, right? The stuff about calling Brad Raffensperger and leaning on him to change votes in your favor, you're not doing that in your capacity as president. You're doing that in your capacity as a candidate for president, right? And so I think there's a lot of that indictment that survives comfortably if you adopt a reasonable definition of official acts. And I'm pretty confident that neither John Roberts nor Amy Coney Barrett, I would have said until oral argument, Brett Kavanaugh too, but after oral argument, I'm not confident about Kavanaugh. I am confident that the other two are not going to adopt a definition of an official act that swallows all of human behavior. Yeah, I was going to ask you, so if there were a 6th, it would be Kavanaugh?
Or Gorsuch, I suppose. But I think both of them were kind of troublingly broad in their conception of the matter. I wouldn't count on either of their votes for something reasonable right now.
One last thing on this. So it's remanded back to Cannon, or excuse me, Chutkin.
Very different.
But doesn't that also extend this, because it creates a period of, Jack Smith's got to decide what is, official, what's not. The defense can then, object, right? Like, doesn't that create a lot more churn potentially if it's a complex ruling?
It creates more churn if Jack Smith decides to defend the indictment as written.
Got it.
But you could imagine a version of this indictment that was stripped down to the bare facts that do not raise any of the concerns that the Supreme Court identifies, that are just purged of that stuff. And, now you can't do that. You can't describe that until you get the Supreme Court ruling, but you can bet your butt that Jack Smith's office has anticipated a variety of options and rewritten, drafts of the indictment in order to accommodate various ways that the Supreme Court could proceed.